Messy desk or clean desk? What does it tell about you? If I have a messy desk, do I have a messy, complicated mind? And if my desk is clean and clear, can I think in a focused way? I don't know. I've done both. I tend to clear off the desk and then piles start accumulating. And the piles are good so that I could repeatedly go to a certain file or refer to a reference guide and it gets out of hand. And I have a desk at home where I am now, and I have a desk at the office. This is where I do some virtual court appearances. I film these videos. And yes, I do written work as well. So that's where we are. Adjournments of cases. I was scheduled to be on trial today, and one counsel asked for an adjournment. Now we're doing the dance of the adjournment. Sometimes that happens in person, and someone will say, December 1, no good. December 3, in the afternoon, I'm only available in the morning. December 7th, we do that. So now we're doing this by email, and we're in November, and the dates we're getting are in March. And, in the emails, there's miscommunication because one counsel said I'm available on this date and only, the afternoon of this other date, and I'm available a full day. Gave 3 dates. Of the 3 dates, 2 counsel was available all day, and on the third date, the counsel was only available half day. The other side agreed. I'm the third wheel in this case. The other side agreed. The court replied back, all right, 2 full days, and one of the days was the one where that counsel was only available half day. So then the other attorney replied, something like, great, thank you, confirmed. But the first attorney said, I'm only available half a day on that day that you made a full day. We're still dancing in that case, the adjournment. Different scenario. I am scheduled on a different matter to be on a pretrial conference in December. I was available when it was set. I subsequently I became involved in another case that received a date of slightly higher priority. Now we want to adjourn that other date. I thought my associate could do it. He's unavailable, and now opposing counsel doesn't want to adjourn. You were available when the date was, so now we have to go back and forth, power struggle, wrangling. So we're going to have, in advance of that pre-trial conference, our own mocked up, made up, scheduled conference, settlement conference, to see if we can resolve. If we can resolve it, that date will be moot. We won't need the settlement conference. We could waive it. We would have settled and probably put it into writing. And if we can't settle this settlement conference, well, then I'm going to have to seek court permission to adjourn it or get coverage from a friend or a colleague to cover it. So the dance of the adjournment, I need to put background music to this. The dance of the adjournment, it's like that in all the cases, at least the cases that are in litigation. A significant part of my practice involves resolving matters within my office. So estate planning, we resolve that in the office. Dialogue between client, I take what you want, what you need, what you require, and place it in writing. We also settle guardianship matters, probate matters, divorces without court intervention. Where appropriate, when possible, we settle the cases. We settle litigated cases, and we do not allow our estate planning cases to become involved in litigation in the future because we draft them tightly and expertly drafted.